After 11 years as the perfect tenant, my landlord suddenly tried forcing me out with fake violations, but one forgotten folder exposed every lie he sent. Let me take you back to before any of this started. Not the week the first notice arrived, not even the month. I want to take you back about 6 months before the violations began, because that is where, looking back, the plan first showed its edge. It was a Tuesday afternoon in early spring. I was in my shop doing the kind of midday administrative work that never ends when you run a small business, going through vendor invoices, answering emails, checking what we were running low on, thinking about the summer display. My phone rang, and it was Patrice. Patrice worked for Crane's property management company. She handled the day-to-day correspondence between tenants and the management office. Maintenance requests, lease paperwork, the kind of routine communication that keeps a commercial building running. I had spoken with her plenty of times over the years. She was organized, professional, and reasonably easy to deal with. I had no particular complaints about her. She opened the call with small talk. How was business? How was the spring looking? I told her things were good, spring was shaping up well, the usual. And then she said she was calling because my lease renewal was coming up, and she wanted to make sure I knew all my options. She asked whether I had considered a shorter-term renewal, 1 year or 2 rather than my standard 5. She said the market was shifting, that flexibility might serve me well in the current environment, that a shorter term gave both parties more options. She was pleasant about it. There was nothing in her voice that sounded like pressure. If I had been half listening, I might have thought she was just being thorough. But I was fully listening, and something about it sat wrong with me. I had been in that building for 9 years at that point. I had renewed twice before, both times on 5-year terms, and neither time had anyone called me to suggest I might want less security. The market shifts she mentioned were real, but commercial real estate always has a market somewhere. I could not point to any one thing she had said that crossed a line, but the call had a different feel than any call from Patrice had ever had before. I told her I preferred the 5-year term. She said she understood and that she would send the renewal paperwork over. We said goodbye. And I sat at my desk for a few minutes afterward, thinking about why that call had left me feeling slightly uneasy. Then I got back to work. I signed the renewal when the paperwork arrived. The signed 5-year lease went into the accordion folder behind the tab labeled Lease Documents. About 2 months after that call, I was driving to work on a Monday morning. The building I work in sits on a corner, so I can see the front and side entrances as I approach, and as I got closer, I noticed something I had not seen before: a commercial real estate sign. One of those large yard-style signs, white with colored lettering, the kind you see on vacant lots or properties being offered for sale or lease. It was mounted near the building's front entrance. I slowed down and read it. It had a brokerage name and a phone number. It was clearly placed there deliberately, not blown there by wind, not left by accident. I parked and sat in my car looking at it for a moment. I thought about the phone call from Patrice. Then I got out, walked close enough to read it clearly, and took a photograph with my phone. The morning was cold and quiet. I stood there long enough to make sure the photo was sharp and that the building was identifiable in the frame. Then I went inside and opened my shop. By Wednesday, the sign was gone. No email from the management company, no notice to tenants, no explanation of any kind. It appeared on a Monday and it was gone before Thursday. I sent Patrice a brief, carefully casual email that same week. I told her I had noticed what looked like a real estate listing sign on the building earlier in the week and just wanted to check in. Was there anything tenants should know? I kept it conversational, as if I was only mildly curious. She replied that the sign had been placed in error and that it was not an issue. 4 words of explanation and a polite close. I printed her reply. I printed my original email, too. I added both to the accordion folder. That was the first mistake they made in writing. At this point, I want to be clear about where my head was. I still was not certain that something deliberate was being constructed. I had a phone call about a lease renewal that felt slightly off, a sign that appeared and disappeared, and a short email with no real explanation. None of that, on its own, was proof of anything. I had a business to run. I had a staff to manage, inventory to buy, customers to take care of. I was not in the business of building legal cases against my landlord. I kept the documents because I kept all documents. That was the sum of it. But I was paying attention. I think that is worth saying plainly. I was paying attention. 6 weeks after the sign came down, the first violation notice arrived. It came in a formal envelope from the management company on their letterhead, dated and signed by someone I had not dealt with before from their compliance department. It cited noise complaints from other tenants in the building. It described what it called repeated excessive noise during business hours, sounds levels that allegedly disturbed neighboring units, and it said the complaints had been filed with the management office. It gave me 30 days to remedy the situation or face further lease action. I set it down on my desk. I read it once through. Then I read it again more slowly. And then I did something that I now realize I had been training myself to do for years without knowing it. I got up from my desk, walked to the back office, and pulled the accordion folder off the shelf. I went to the section labeled Inspections and Compliance. I went through every piece of documentation in that section: annual inspection reports, fire marshal visit records, any written communication from the management company about the condition or operation of my space. I went through all of it. There was no noise complaint. Not one. Not a sentence in 11 years of written communication between me and Crane's management company that mentioned noise from my unit. Not a verbal note, not an informal follow-up, not a line in any inspection summary suggesting that any other tenant had ever raised a concern. I went to the section labeled Tenant Correspondence next. Every email I had printed, every letter I had kept. The word noise appeared exactly once in an email I had sent asking whether planned construction work in a neighboring unit would affect my customers during a busy period. That was it. 11 years. One mention of noise in a concern I had raised about someone else. I wrote a letter to the management company. I was polite. I was precise. I told them that I had reviewed my complete records for 11 years of tenancy and found no documentation of any prior noise complaint, formal or informal, verbal or written, from any source. I asked them to provide the dates of the alleged complaints, the nature of the noise described, and the identity of the tenants who had filed them so that I could understand and address the concern. I sent the letter by certified mail and kept a copy. Their response came about 10 days later. It acknowledged that the complaints had been informal in nature and had not been formally documented. It said they would note my written response and monitor the situation. I read that response carefully. Informal in nature, not formally documented. I thought about what that meant in a legal context, and I added it to the folder. The second violation notice arrived 31 days after the first. This one cited a signage infraction. It stated that my storefront signage was not compliant with the building's commercial standards, specifically regarding size and placement. It quoted a section of my lease that described signage requirements and implied that my current signage had not been properly authorized. I opened the accordion folder to the section labeled Property and Space. And there it was, exactly where I had put it 6 years earlier, a written approval letter from Crane's management company, dated, signed by the property manager at the time, explicitly approving my current signage. Not signage like mine, my signage. The specific sign, with its specific dimensions and specific placement and specific materials, had been submitted for approval, reviewed, and approved in writing by his office 6 years prior. I had kept that letter because it was correspondence, and I kept correspondence. I had not thought about it once in the 6 years since I filed it, and here it was. I sent a copy of that approval to the management company with a brief written note. I said my current signage was the signage they had approved in writing, referenced the date of the approval and the name of the signatory, and included the document as an attachment. I was brief. There was not much else to say. They did not respond. I added the second violation notice, my note, and the approval letter to the folder, paper-clipped together. I want you to sit with what was happening here for a moment. I was receiving formal lease violations, each one designed to look like a real compliance problem, and each one was being undone by a document that the management company itself had generated and sent to me. They were, in effect, contradicting their own records, and they were doing it, I believed, because they expected me not to have those records anymore. The third violation notice arrived about 3 weeks after the second. Fire code concerns. It said that issues had been observed during a recent building inspection of my unit, and that remediation was required within 30 days. It cited specific fire code sections by number, which gave it the weight of regulatory authority. I had my most recent fire inspection report in the accordion folder. It was right there in the Inspections and Compliance section, behind the tab where it had always been. The inspection had been conducted by the Portland Fire Bureau. I had passed without a single comment or correction required. The report explicitly stated that the unit was in compliance. The date was printed on the first page. I called my attorney that afternoon. Karen Aldridge has been practicing commercial lease and business litigation law in Portland for more than 20 years. When I called her and described what had been happening, the 3 violations, the pattern, the timeline, the phone call about shorter terms, the sign on the building, she said, "Bring me everything you have." I carried the accordion folder to her office on a Thursday morning. I set it on her conference table and I opened it, pulling the sections out one by one and laying them across the surface. The table was large and there was a lot of paper. Karen went through it section by section without rushing. She was quiet for most of it. I watched her read the signage approval letter and then look at the second violation notice and then look back at the letter. I watched her read the fire inspection report and then the third notice. I watched her read the response from the management office acknowledging that the noise complaints were informal and undocumented. After a while, she set everything down and looked at me directly. She said, "Susan, in each one of these situations, you have a document that specifically contradicts the violation." I told her I had just kept everything. That was all it was. She said, "I know, and that is exactly why this works." We sent a formal attorney's letter to David Crane's management company. It addressed each of the 3 violation notices individually. For the first, it cited the absence of any documented noise complaint in 11 years of written communications and attached the management company's own response, acknowledging the complaints were informal and undocumented. For the second, it attached the signed approval letter for the signage and noted that the current signage was the signage his own office had approved in writing 6 years earlier. For the third, it attached the fire inspection report and noted that the unit had passed its most recent official inspection with no corrections required. The letter also named the pattern: 4 months, 3 violation notices with no factual basis, 0 prior history of any compliance concern in 11 years of tenancy. And it referenced specifically the phone call about a shorter lease term and the photograph of the commercial real estate sign that had appeared on the building's exterior 6 weeks before the first notice and disappeared within 48 hours. It asked the management company to cease issuing notices unsupported by documentation, and it made clear that any further action would be regarded as part of a coordinated pattern of conduct intended to pressure a lawful tenant into vacating a valid lease. The fourth violation notice arrived 10 days after our letter was received. This one cited general lease compliance issues, without naming any specific concern. Karen was not surprised. She said that when the documented claims fall apart, the tactic sometimes shifts to something vague, something that creates the impression of ongoing problems without having to specify any one thing that can be directly refuted. It keeps pressure on without giving the tenant anything specific to disprove. But there is a limit to how long that kind of pressure holds when you have an attorney, organized records, and the patience to stay in the fight. And then something happened that changed the shape of the case entirely. While Karen was preparing our response to the fourth notice, her office ran a standard public records search on the property: ownership history, permit filings, zoning records, public civil court filings. It is the kind of background research that a good commercial attorney does before entering litigation. She called me after she had been through the results. David Crane had done this before. 3 years earlier, there had been a different commercial tenant in the same building, a small accounting firm that had occupied a ground floor unit for 7 years. That tenant, too, had received a cluster of violation notices over a short period of time. That tenant had not maintained organized records. That tenant had not had an attorney ready to respond. The pressure had built, the notices had kept coming, and eventually that tenant had left. After the accounting firm vacated, the unit was re-leased at a substantially higher rental rate. There was a civil complaint on public record, filed but never fully litigated, settled quietly, without a verdict, without headlines. The complaint outlined the same pattern that Karen was now looking at in my case. Multiple violations in a compressed time frame, no prior documented history of compliance problems, a lease renewal period that was disrupted by the violations, and a management contact who had been involved throughout. The management contact was Patrice, the same Patrice who had called me about a shorter-term renewal. The lie had worked before. It had worked because that prior tenant had no folder. Karen also found something else in the public record, a building permit filed about 18 months before my situation began, for renovations to 2 of the commercial units in the property. The scope of the work was described in the permit as conversion to flexible short-term commercial configuration. 2 units, ground floor, neither of them mine. But the intention was written there in the permit language, plain as anything. Someone had been planning to reposition this property for a while. The violations, I now understood, were not improvised. They were a mechanism in a larger plan that had been in motion long before the first envelope hit my mail slot. The lie worked until the paperwork caught up. That is the simple version of what happened to the accounting firm, and it is the simple version of what almost happened to me. The strategy had worked before because no one was watching closely enough, and because the person it was used against did not have years of organized documentation sitting on a shelf. It worked the way a lot of dishonest things work. Quietly, in the space between what happened and what can be proven. I want to tell you how I felt when Karen told me about the accounting firm, because I think it matters for the rest of the story. I did not feel rage. I know people expect that. The revelation that someone targeted you deliberately, that it wasn't random or impersonal, that it was a strategy they had already run once before and gotten away with. You would expect that to produce fury. What I felt was something quieter and harder to name, something that settled rather than rose. I had 11 years in that building. I had been a good tenant, a reliable business, a genuine part of that block, and someone had decided that my reliability was an obstacle to something he wanted, and had tried to manufacture reasons to push me out, and had done it before to someone else who was not ready for it. I sat with that for 2 days. Just let it settle. I talked to Karen once, briefly, to tell her I was ready to move forward. Then I thought about what I actually wanted from this. I thought about the accounting firm. 7 years in that building, and they had left because the pressure was more than they could manage at the time with what they had. I thought about whether anyone had ever sat across a table and looked at what had been done to them and called it what it was. I thought about how many times things like this succeed simply because the person on the receiving end doesn't have the tools to name it clearly. And I thought about a quieter thing. I thought about the fact that for 4 months I had been responding to these notices as though they were real, as though there was some genuine compliance concern I needed to address, some legitimate grievance I needed to take seriously. I had been treating them with more respect than they deserved, and in doing that, I had been, in a small but real way, participating in the fiction that they were legitimate. I did not need to expose him. I only needed to stop protecting him. Because that is what I had been doing, without fully realizing it. Every time I responded to a violation notice as though it were an isolated incident, as though each one were its own separate problem to be addressed on its own terms, I was managing the pressure rather than naming what it was. I was responding to the performance rather than the purpose behind it. Stopping that meant saying, plainly, with documentation and legal standing behind me, exactly what had been happening and for exactly how long. We filed a wrongful eviction lawsuit on the theory of constructive eviction. The argument was that Crane had engaged in a documented, coordinated effort to pressure a lawful tenant into vacating a valid lease by issuing serial bad faith violation notices with no factual basis. That the effort was part of a broader pattern, evidenced by the prior tenant, that was designed to clear the building's commercial units for a sale or releasing at higher rates. The accordion folder, now reorganized into a formal exhibit binder by Karen's office, tabbed and paginated and indexed, was the backbone of the filing. Every document in that binder had been created by someone. The inspection reports were created by official city inspectors. The approval letter for the signage had been created by Crane's own management company. The noise complaint correspondence had been created by his office. The lease documents had been created and signed by both parties. The photograph of the sign had been taken by me. The email exchange about the sign had been initiated by me and responded to by his office. There was not a single item in that binder that I had manufactured. Every piece of it was real. Every piece of it was dated. Every piece of it told the same story. Karma did not arrive loudly. It arrived with proof. The deposition was calm. That is the word I keep returning to. There were attorneys on both sides, a court reporter in the corner, a conference room with neutral walls and a long table, and the particular kind of silence that formal legal proceedings create. Crane sat across from me. His attorney asked questions, and I answered them. When the questions touched on the violations, I referenced the exhibit binder, because everything relevant was in there and Karen had organized it so that any document could be found in about 30 seconds. At one point, Crane's attorney asked me why I had kept correspondence from 6 years ago. I said, "I keep all correspondence. That's how I run my business." He did not ask a follow-up question. There is something I want to say about that moment, and ones like it, because I think it is important. I was not trying to be clever. I was not performing composure. I genuinely meant what I said. I keep my records because I am organized and because organized people keep their records. The fact that those records turned out to be the most important thing in this case was not something I planned. It was a consequence of simply having always taken my business seriously enough to file the paperwork. Crane sat through the deposition without looking at me much. I noticed that. His attorney did most of the work of keeping things moving, and Crane answered the questions directed at him in short sentences, the way people do when they have been coached to say as little as possible. There was a moment, during a sequence of questions about the timeline of the violations, when I watched him look down at the table while his attorney leafed through papers. He knew by that point what the binder contained. He knew that the document contradicting every notice he had filed was in there, on a tab, behind a label, organized and dated and waiting. There was something in how he held himself in that room that told me he had not expected this. He had expected me to have some records. He had not expected me to have all of them. Discovery produced the financial and operational records from Crane's company that confirmed what Karen had suspected from early on. There had been a prospective buyer for the property during the same period the violations were being filed. That buyer wanted the commercial units cleared of long-term tenants or on short-term leases before the sale closed. The timeline, laid out in the discovery documents, mapped with almost clinical precision onto what had happened. The call from Patrice about a shorter renewal, the listing sign on the building, the first violation notice, and then 3 more in rapid succession, all within the window that made sense if Crane was working toward a specific transaction. My lease was not flexible. It was a signed, valid 5-year commercial lease, countersigned by his management company, filed with the county, held by a tenant who had not violated a single term of it in 11 years. Every violation he had filed was contradicted by documentation that his own office had either created or signed. The signage approval letter was on his letterhead. The 11 years of noise-free correspondence came from his files as much as mine. The fire inspection had been conducted by the city, not by me. The receipt was dated. The alibi was not. The settlement was reached before the case went to a full hearing. I cannot share every term. What I can tell you is that David Crane was required to pay me 3 years of calculated lost revenue based on the income I had been producing at that location. 3 years, calculated against the numbers from the highest revenue commercial tenant in his $7 million property. He also had to honor my lease in full. I stayed. He paid. Patrice no longer works for his management company. I want to tell you what the building felt like in the weeks after the settlement, because this is part of the story too. It did not feel triumphant exactly. It felt settled. It felt like the version of things that should have always been true had been confirmed as the version that was true. My name was on a valid lease. My space was my space. The work I had done over 11 years had not been erased by 4 months of manufactured pressure. That was all it was. Not a victory in the sense of someone being defeated, though someone had been, more like a correction. The record had been straightened. My customers did not know any of this. My staff knew some of it, because they had noticed the stress I was carrying during the months the violations were being issued, though I had tried to keep it from affecting the shop. When the settlement was done, I told them it was resolved, that we were staying, that nothing was changing. That was the whole announcement. We opened the next morning the same way we had opened every morning for 11 years. Let me tell you about the last time I opened the accordion folder in its original form. It was a few weeks after the settlement. I was reorganizing the back office. The folder had been in the same spot on the same shelf for 11 years, and it was time to give it a better home. I took it down and I went through it slowly, not looking for anything, just going through it the way you go through something that has been part of your life for a long time before it becomes an archive. I found the original lease from my first year in that building. I found a note from the first inspection where the fire marshal had written that the space was well-maintained and clearly managed with care. I found a letter from the 5th year where Crane's management company had written in passing that my business was an asset to the property's commercial portfolio. An asset to the property's commercial portfolio. In writing, signed by his office, filed in my back office for years without me knowing I would one day need it. I stood in that back office for a while with the folder in my hands. I thought about all the ordinary Tuesday afternoons when I had added something to it without much thought. A lease renewal, filed. An inspection report, filed. An approval letter for a sign, filed. None of those moments had felt like anything. None of them had felt like I was building something. They just felt like staying organized, like doing what you do when you take your work seriously, and you have been around long enough to know that paperwork is not a burden, but a record. Someone had looked at 11 years of that work and decided it was an inconvenience to their plans, and 11 years of that work had looked right back at them. And if stories like this remind you that truth has a longer memory than lies, subscribe to my channel for more stories, because sometimes karma is just the evidence finally being read aloud. I carried the folder in a box to the new shelving unit I had installed. I organized it next to the exhibit binder from the lawsuit. I did not throw a single document away. I never do. What I want you to take from this, really take from it, not as an abstraction but as something practical, is that the accordion folder was not a strategy. It was not something I built because I suspected trouble. It was not the result of a prepared legal mind or advanced planning or any special awareness of what might come. It was the result of 11 years of taking my business seriously enough to keep its paperwork. I want to say something to the people watching this who are currently in the middle of a situation like this one. If you are being pressured out of something you have a right to, a job, a lease, a role you have held with integrity for a long time, and the pressure feels manufactured, and the complaints feel disconnected from your actual conduct, I want you to hear this. Your history is your evidence. Everything you filed, every email you kept, every letter you responded to in writing, every time you got something confirmed on paper rather than just verbally, that is your record. It may not feel like much right now. It may feel like boxes in a closet or files on a hard drive that nobody is asking about. But organized history has a way of becoming exactly what you need it to be at exactly the right moment. Start now if you haven't. File the things that seem small. Get the approvals in writing. Respond to formal claims with formal documentation. Keep copies of everything that comes to you and everything you send back. You may never need it, but the people who want to move you out are counting on the chance that you don't have it. The people who run the kind of game that David Crane tried to run are counting on a specific assumption about ordinary people. They are counting on the idea that history disappears, that because your record of good behavior was built quietly over a long time in unremarkable daily increments, it left nothing behind worth presenting. They are counting on you not having the approval letter from 6 years ago. They are counting on you not having the photograph from the morning the sign appeared. They are counting on you feeling like the smaller party in a legal and financial dispute with someone who has more resources and more experience in these matters than you do. They are counting on you not being organized. What I know now is this. Organized people with documented histories are very hard to manufacture violations against. Every piece of paper in that folder was just a piece of paper. Together, 11 years' worth of pieces of paper told the complete, verifiable, date-stamped story of what kind of tenant I was, what kind of landlord Crane was, and what the actual timeline of events looked like. Not the story he needed the court to believe. The story that actually happened. He had filed 4 violations in 4 months. I had filed 11 years of truth. There is no version of that contest where 4 months wins. And I think it is worth saying plainly what the real cost of what he tried to do was. Not to me financially, though that number was real. The real cost was to the accounting firm that came before me. 7 years of work in that building, and they left under pressure that should never have been applied. I do not know where that business is now. I do not know whether they rebuilt somewhere else, whether the disruption set them back in ways they are still feeling. What I know is that the same strategy, used against the right person with the wrong amount of documentation, produces a very different result. I stayed because I had the folder. They left because they didn't. That difference has nothing to do with character or strength or who deserved what. It has to do with paperwork. That is worth sitting with. Karen said something to me after the settlement was finalized, standing outside her building in the late afternoon. I thanked her. She said, "Susan, I've had cases where the client had the right on their side but nothing to show for it. You had 11 years of documentation. Cases like yours are why I tell every business owner I meet, file everything, even the things that seem small. Even the things that seem small. That phone call from Patrice about the shorter-term renewal, just a phone call. The photograph of the sign, a 2-second impulse standing next to my parked car on a cold morning. The approval letter for my signage from 6 years ago, a sheet of paper most people would have long since thrown out. None of those things felt significant when they happened. Together, they were the reason a settlement happened instead of an eviction. He had needed me gone before my new 5-year lease locked him in for another full term. But I had already signed that lease. It was already in the folder. In the most essential sense, he had already lost before the first envelope was sealed. He just did not know what was in the folder. Before I close, I want to ask you something directly. Have you ever been the most reliable, longest-standing person in a situation, a job, a lease, a partnership, a family role, only to become a target the moment your reliability made you inconvenient? What did that shift look like? When did you understand that the relationship had changed, that the history you had built was being treated as an obstacle rather than a reason to stay? Tell me in the comments. I read every one of them. If your story is one where the record saved you, or where you wish you had kept better ones, or where you are still in the middle of figuring out what to do, and you are looking for the knowledge that other people have been here and come through it, I want to hear it. The people who watch this channel understand something that a lot of people learn the hard way. Fairness is not automatic. It is something that has to be documented, protected, and sometimes carried in a worn accordion folder for 11 years before the right moment to open it arrives. That moment always comes. Susan Mercer knows that now. She knew it before too. She just didn't know she knew it until the moment she set the folder on a conference table and watched 11 years of organized truth do the work that no argument, no confrontation, and no amount of anger ever could have done on its own.